Good. So this is our the final event of our Aspen Forum. This is a chat with the commissioners. If you imagine the fire pit on, you can even consider it a fireside chat. It'll be moderated by Tony Romm of Politico, and I just have to say that I read Tony's stuff, but I didn't know what he looked like. And he was sitting next to me on the flight on the way here, and then I was worried he would see what it was I was watching in the movie. And he said he didn't see, even asked what it was, and I said I was watching Men in Black, and he said, well, thank you for not lying about that, but I actually have to admit it was Men in Black 2, not Men in Black. Anyway, so we're very pleased to have this chat with Joshua Wright and Julie Brill, and I will just leave it to them. Take it away.
Great, thanks so much, and thanks guys for having me. And thank you to all of you for sticking around and not booking for the first flight after this morning. As has been said, I'm Tony from Politico. You know the two commissioners sitting next to me. You know, I could have done a bio for the two of you, but we talked yesterday for a long time about sports, and so I figured that'd be a hilarious place to start, mostly because I was confused that Commissioner Brill could be both a Heat and a Yankees fan. That kind of bothered me, and Commissioner Wright found out you're a Pittsburgh fan.
What bothers you about that?
Oh, it's just wrong. It's just morally wrong.
Well, wait, I'm morally wrong on both sports.
Oh, absolutely.
So there we go.
You know, the entire theme of this obviously has been creative disruption, talking about new things, new business models, new ways of looking at old technologies and ways of doing business. And so I thought it would be a great way to start our discussion today by asking about the FTC and kind of where the agency itself is going at a time when, you know, it's confronting myriad challenges in technology, privacy, data security, et cetera. We'll get into all of that. But with the agency turning 100 soon, talk about where the FTC is. You know, has its authorities really kept pace with some of the technologies it's trying to regulate? Whichever one of you wants to grab it first.
Okay. Well, so I'm really glad to be doing this fireside chat. I just want a warning out there for all of you. I did a fireside chat at the end of last week in Sun Valley, and we even had a video of a fire. And as I was giving this presentation, smoke from the wildfires started inundating the room. So hopefully that won't happen here. We did leave the video behind. So the FTC at 100, you know, it'll be in 2014. Obviously not quite yet, but it's coming right up. You know, my view. I've been a commissioner for 3 years. I'd worked with the FTC for many, many years before that as a state law enforcement person. But really, I didn't get to know the agency until I got there. It's completely different seeing it from the inside than from the outside. I've got to say, I think, you know, this is going to sound kind of Pollyanna-ish, I suppose, or self-congratulatory. I think we're a remarkable agency. I think we're a remarkable agency on a number of different levels. First of all, although the commissioners are from different parties, we actually agree a lot on a lot of different things. We all want to be data-driven. We all want to do aggressive enforcement where appropriate and not do aggressive enforcement where it isn't appropriate. I believe we've been cautious in the use of some of our unique authorities, and I know we'll be getting into that a little bit later. And we've also, I think, been very clever or smart about using the different authorities that we have in different ways. So I talked this morning about how we use law enforcement work to set the ground floor for technology firms, and actually for all firms. You know, what are the lines that can't be crossed? But we don't stop there. What we also try to do is help companies innovate in ways that we think would be helpful to consumers. Now, folks don't have to listen to us. They don't have to follow our reports. They don't have to do what we say. But if they are interested in being pro-consumer, pro-privacy, pro-competition, whatever the issue is, they can look at our reports and they can say, okay, this is where the agency thinks we ought to be going in terms of our innovation, in terms of how we can be more protective of consumers and competition. So I think we've done a really good job at using the different tools that we have. I'd say that this has probably been true, you know, certainly for the last 5 to 10 years, and probably for about the last 20 years. And so I think we have a really good record.
So you don't feel as if you're being outpaced by the technologies that you guys examine, regulate, enforce, et cetera?
So that's a great follow-up. It's always a challenge to keep up with the very latest in technology. We do employ a chief technologist, and we've had a great run in our last 2 chief technologists. We've had leading lights in the technology field between Ed Felton and Steve Bellevin. so, we realize what our shortcomings are, and we, try to staff up appropriately. And when we don't have people right on staff, of course, we reach out to the marketplace and we reach out to other competitors or consumers or, customers to try to find out what's really happening in the market. So it is always a challenge. I don't want to underemphasize or underestimate the challenges that we face in that area, but we recognize that we're not engineers. Right, we're lawyers and we're economists, most of us, and so we try to fill that gap.
Sure, Commissioner Wright. We were talking about technology before we were sitting up here talking about email. You're new to the agency. Has this agency been able to stand the test of time as we get close to this 100-year mark?
Mixed answers on the question. I think one advantage we have, and first let me start on the positive answer, where I think I agree with Julie entirely, that the agency takes care, and is a remarkable care at that, to ensure in places where my last stint at the agency we didn't have a chief technologist. We do now. I've been able to use that to great advantage in cases that involve technologies I'm not familiar with. I think that's been a great addition, but more importantly, I think it's an example of the types of things the agency does to ensure that it's not getting outpaced. Getting outpaced is a real fear, and that's where the mix and the answer comes in. I have a slightly sort of different tack on one of the reasons I think that we're not getting outpaced. This debate over whether the agencies are getting outpaced and has, a huge debate in antitrust around the time of the Microsoft decision. 99% of the academic articles in the world were, can the antitrust laws catch up? One of the institutional features that I think a competition agency can have or consumer protection agency can have that protect against us are sort of two things. One is a culture that is data-driven, that's doing evidence-based policy. I think, to the extent that you have new technologies, being attuned to the data, being able to ask self-reflective questions, say, well, we did this policy, the outcomes were uncertain, let's test it, and be willing to go where the answers take us. They may take us to a place where we say we need to amend something. They may take us to a place where we say we made a mistake. We may learn something that helps us improve policy. And I think my experience at the agency has been that the place is attuned to doing data-driven, evidence-based policy in ways that I think are generally helpful. There are some exceptions to that, and we'll get into some of those. I think one other major advantage the agency has in terms of keeping up with changing technology is the substantive doctrine itself. And in antitrust, a rule of reason standard, the rule of reason standard has passed the test of time in the sense that what we're looking at ultimately is the question of the impact of some conduct, merger, whatever else, on consumer welfare. That question can be asked of old technologies, the question can be asked of new technologies. It may be harder where in antitrust, for example, the theory of harm is that we're going to impact innovation some way. Theory tells us less, we have to rely on data more. It gets harder, but the question can be asked, and we have a wonderful economic staff and people who are very clever at getting at ways of answering those questions. So I think the underlying substantive doctrine is one of probably the underrated advantages that our agency has, on top of having a culture that is I think where evidence-based policy is fairly well ingrained. It's also having that substantive doctrine.
But it is hard, just to follow, it is hard to predict, where consumer welfare will come out in a lot of the high-tech areas. We've done mergers in high-tech, we've done anti-competitive practices cases in high-tech, and that's really the biggest challenge. I mean, the laws are the same, the HSR rules, the Hart-Scott-Rodino rules, the reasonableness standard, all those standards are the same, whether you're talking about low-tech or high-tech, but our predictive abilities do become more difficult. I think it's more difficult for everybody, not just the agency. I think it's also more difficult for business to predict exactly where things are going to go.
Sure, you mentioned standards. I think one of the things I've heard a lot about over the course of this conference has been the topic of unfairness. And Commissioner Wright, you put out a draft policy statement kind of exploring unfairness. I want to get a conversation going between the two of you on the sorts of ideas you've proposed, but it might be instructive if you start and kind of outline for folks exactly what it is that you've proposed.
Sure. So I issued a proposed policy statement. This is my 4th time at the agency, twice as an intern, this time with a slightly bigger
interns
office.
Count?
They count on my government service record, which is all that matters. So this time slightly bigger office, but the Section 5 issue is something that I followed and wrote about a great deal as an academic. And I think it is one of the areas where there's some especially low-hanging fruit to be plucked in providing some guidelines. My own view, if you look at the administrative processes available to the Commission and unfair methods of competition cases, I think the record over the last 30 years is in cases where the ALJ rules for the defendant, the reversal rate by the Commission is 100%. I don't think anybody looks at that and says that's a data generating process that looks normal to me. And it raises some questions about our responsibilities in using Section 5 and putting folks on notice about how we're going to use it. The main advantage, I think, to putting out guidelines in the Section 5 context, certainty for businesses is great. We should do that. If you look out into the world at practice notes from law firms about Section 5 jurisprudence, whenever we do something, Google, Intel, what have you, that will come out and say, what does Section 5 mean? And they'll all come out every time we do a Section 5 case. They'll all essentially say, well, I don't know, but don't do what was in the last case, right? So don't have invitations to collude, I think, is the clear guidance we can give right now. But I think the big advantage is not so much in certainty. That matters a great deal. We have 48 sets of live guidelines on topics far less important than Section 5. So that's partially a big deal. I think a bigger deal is that we get, because of the administrative process advantages, the opportunity to extract settlements by using Section 5 whenever we want. Okay? I think that's a real problem, and I think it undermines our ability to go out and influence substantive antitrust law. One of the great things the Commission has been able to do over the 100 years is have a very positive impact on substantive antitrust doctrine. The threat of using Section 5 in that way, I think, undermines our ability to do that effectively. Now, exactly what cases to do and not to do, your mileage might vary on exactly how the scope of Section 5 should lay. A couple of pieces of relatively low-hanging fruit that are part of my policy statement. One, that we should have guidelines. Two, that for an unfair methods of competition statute, there should be a requirement of showing harm to competition. There's 100 and something years of antitrust jurisprudence that's had the benefit of modern economics to define what those terms mean. People in the antitrust bar know what they mean. We have to prove them in the antitrust laws. I think saying that harm to competition is a necessary part of an unfair methods violation is, again, low-hanging fruit. This is a position Bob Potofsky had. This is a position Chairman Leibowitz had. I think both of those things are relatively uncontroversial. How to treat efficiencies is a more controversial topic. Guidelines that said harm to competition, I think, would be a wonderful place to start and would take care of a lot of the problems with Section 5. What to do about efficiencies, I have a pretty stringent standard. How I define an unfair method is to say the conduct has to harm competition and not have any cognizable efficiencies. One response I'll get from people, that's a very, very strict standard. It eliminates all the Section 5 cases. Nonsense. One, it says we have to bring them in federal court, where we bring cases and win all the time. Right? If we have a case where there's lots of harm and little benefit, the statement says, you know what, take that case to federal court, where the law says if you can prove there's competitive harm, you win. Go there and bring the case. The question to me is, where should we be able to use these special administrative advantages we have? If you believe, like I do, that it's the combination of an unbounded statute with these administrative process advantages that are at the heart of the problem, then the brighter line rule, the better. Mine's a very bright line rule, right? Requires, and defendants can't just come in and say there's something efficient. It has to be tied to cognizability in the way we do in our merger guidelines. I've never heard an antitrust practitioner say they think staff is too easy on them on the cognizability of efficiencies. Never heard it in my life. So there's some bite to the test. Now, Commissioner Olhausen proposed something, I think, less bright line than that, a disproportionality test. There are other approaches that would do something more akin to a straight balancing of the rule of reason. I think both of those invoke the classic rules versus standards debate and have different costs and different benefits, but are all sort of fairly reasonable places to start. Mine starts, and my view is, and I'm happy to talk about it more if we go into it, that it really is the combination of the administrative procedures available to us with the ambiguous and vague rule that are the heart of the problem, and a bright line is the way to fix that. One last note on my standard also does things, I think, the core problem, if you look at, if you look at Section 5, the last time the Supreme Court talked about Section 5 was in the 70s. Statutes passed in 1914. Antitrust has had this wonderful economic revolution. We developed the rule of reason, we imported all of this economic content in. That's not happened in Section 5 jurisprudence. There's no need for it to happen. No one litigates. You don't get the benefit of creating law through litigation. And I think updating our approach to Section 5 cases to modernize it the same way that the antitrust laws have been modernized through the rule of reason, the same way that our merger guidelines have updated economic thinking to sort of more closely reflect the way that the agencies think about cases, I think we ought to do for Section 5. There are some things in my guidelines that we would be able to get to that are well outside the scope of traditional antitrust laws. For example, conduct by a single firm that's not a monopolist, where we can prove harm to competition. Traditional antitrust law, not a monopolist, that case is dismissed. Can get there under Section 5 under my guidelines. So I think there's a mix of things in there that attempt to modernize the economics and also try to target our efforts at the conduct that's most likely to be anti-competitive. The stuff that harms competition, where there's no argument about efficiencies outweighing that harm. If you look at our cases over the last 30 years, by my count, and this is fairly subjective, and your mileage might vary on this too, but by my count, about 70% of the cases we've brought in the last 30 years meet my definition. And the argument is over the other 30, and the argument over the other 30 is, should we bring those in federal court and have to prove harm or not? And my answer to that is yes.
And so, Commissioner Brill, I'd love to get your thoughts on this. And taking a step back, I mean, should the commission even go the route of putting out the policy statement in the first place? I mean, we're presuming as part of this conversation that, this is something that's being debated right now, but should we go the route of even putting out the policy statement and then respond to the commission?
Well, that's one of the $64,000 questions. So first of all, let me say that, Josh has put a tremendous amount of thought into this issue, and he's put out a very thoughtful statement. And I really appreciate the work that that he's put into it, and it certainly has sparked a lot of conversation within the antitrust community. Similarly, Maureen has come out with a very eloquent speech with her views on Section 5. And so, with respect to both of my fellow commissioners, I think that I really appreciate the work and the thoughtfulness that they've put into it. We are a deliberative and highly collegial body. I mean, I'm not going to wrestle literally with Josh because he would win hands down. He's been a professional wrestler, just so you know. This is no comment on our sizes. Yeah. But we do wrestle a lot intellectually among ourselves, and that's really to the good. And I think that a good thing for us to do would be to look closely at these statements and make a determination as to whether there is something there that might get us to a place where we could all come down on an agreement. But a couple of thoughts. Okay, first of all, if we were to issue an agreement, a statement, I would not want to see it be a 3-2 statement. I would not want it even to necessarily be a 4-1 statement. I think the power of the certainty, quote unquote, that some folks are looking for, and I want to talk about that in a second, the idea of certainty in competition law. But I think the certainty that some folks are looking for will really only come if you get something that's close to a unanimous statement. Whether it's, we might quibble around the edges, but I think that's going to be important. I also think it's important that it be a 5-commissioner statement, not a 4-commissioner statement. When we did the horizontal merger guidelines, Carl Shapiro was very involved in that. It was part of the Gang of Six. The Gang of Six and others who were instrumental in revising our horizontal merger guidelines waited for Edith Ramirez and I to get to the commission before we finalized it and before we published the final horizontal merger guidelines, because it was important that it be a full 5-commission board before we issued a statement. So I think that's going to be an important aspect too. You know, one concern I do have, frankly, and I'll be really honest here, is, you know, whether we can get to yes, where, you know, you have a vision of a statement that's along the lines that I talked about, where we largely agree. We might quibble on the outskirts, but we largely agree. And I have mentioned to Josh, haven't yet had a chance to talk in full with Maureen about this, and I want to sit down and talk with both of them about all of their ideas. But I have some questions about some of the fundamental premises of the need for a statement. I understand that there are a lot of people calling for it, but truthfully, you know, Josh, I think the term you used in your speech where you outlined your statement was that there were grave consequences in the economy because we do not yet have a statement. By the way, I should do a little footnote here. We have a statement on the consumer protection side with respect to what unfairness means. There are some people here in the audience who don't like the way we've been using that authority. We can talk about that, Darren.
Everybody's going to wrestle today.
That's okay. That's okay. I'm up for it. I'm up for it. So what we're talking about, just to be clear, is on the competition side where we do not yet have a statement. So Josh has said in his speech that there are grave consequences to the economy because there's all sorts of efficiency enhancing services, products, business models that are not being developed because we don't have a Section 5 statement. Now, I've been a commissioner for over 3 years. I have never heard a business executive come in and talk to me about the problems they're having in their business because we don't have a Section 5 statement. Never once. I've heard lots and lots of concerns on the part of the business community with respect to patents, with respect to some of the privacy European issues that we were talking about this morning, with respect to all sorts of privacy issues, with respect to all sorts of competition issues, but never once has anyone from the business community said to me, I mean, someone who is in a business, in a company of some kind, they've never said to me that Section 5 has in any way inhibited their activity. So I kind of question, again, if we're going to be evidence-based, I'd love to see the evidence that our lack of a statement has caused any kind of problem in the economy. I am skeptical that that's true, just based on my own very subjective, observations of what I've seen. Now, the other justification for a Section 5 competition statement that I've heard, and this is something that hasn't so much come from you, Josh, but from others, is the need for us to corral our Section 5 authority so that we are more kind of in line with the Department of Justice, and that there's more convergence, if you will, to borrow a term from this morning, with respect to us and the Department of Justice. And that's, again, a premise that I take some issue with. We are designed in many ways, that is the FTC and the Department of Justice, with respect to our competition authority, to be complementary. We cover much of the same ground, but we're not coterminous. We don't cover the identical ground. There's a Venn diagram where there's overlap, and then there's a portion of the Venn diagram where there's not overlap. So for instance, Department of Justice has criminal authority. I can't throw anyone in jail. I don't have that authority. Department of Justice does not have an administrative process. We do, as Josh was pointing out. And it's very different than going to court and trying to convince a judge in the first instance at the trial level of what you're trying to say. We do, when we're going through our administrative process, if the defendant, respondent, wants to appeal, we then have to answer to the circuit courts of appeal. And that's a very arduous process as well. But they're not, the two agencies are not identical. They're not designed to be identical. They're designed to be complementary. And indeed, Section 5 in many ways, on the competition side particularly, was kind of the heart of what the FTC was designed to, how it was designed to be different from the Department of Justice. If you go back and look at the history and what Louis Brandeis was trying to do after the Standard Oil case, was to create an agency that wouldn't have penalty authority necessarily when using Section 5, but would have the ability to kind of do the innovative stuff, to be very forward-thinking and stop practices that maybe couldn't be stopped in court. So again, this isn't to say that we shouldn't have a statement. This isn't to say that I don't laud the principles that Josh has outlined. I am a little concerned about spending a lot of agency time when, gosh, we have so much work to do, when I'm not certain we'll ever get to a place that will provide the certainty that folks are looking for. And finally, I guess I should say, if I haven't already said this, I don't think I did, there really is no certainty in antitrust law. I mean, there's no certainty under Section 2, and what does monopolization mean? I mean, does anybody really know what that means? Does anyone really know what an unreasonable restraint of trade means? I mean, these concepts are designed to be flexible, remedial, so that we can address new activities. We're here talking about high-tech and disruptive technologies. We need to be able to address new activities that we've never seen before. So if we were to do a statement, from my perspective, it would have to be very flexible, very remedial, and I'm just not sure that's where my fellow colleagues are.
Sure, and I want to come back to this if we have time, but I want to cover some of the other areas that you had mentioned just now. And one of the big ones is privacy. We talked a little bit about privacy in the European context this morning. I want to go over two things. First, do not track, and second, data brokers. When it comes to do not track, we've all watched the W3C. Some of us have sat through W3C meetings or read countless emails from the W3C, and it doesn't appear as if we are remarkably farther from where we started, right? You know, the DAA, that looks as if the advertisers aren't happy with the standard that some of the consumer folks want. There's lots of talk about competing standards coming at the end of the day. So the question is this: has the W3C been a manifest failure on do not track, and are we in some trouble?
You looking at me? Okay.
Yep, looking at you.
Okay, so I understand that people think to use a very tired and probably inappropriate phrase, that the fat lady is warming up her voice and, you know, we're about to be at the end of W3C. I'm not certain that's the case. I do know that it's been a difficult and hard conversation, but I think that's because there are a lot of very important issues at stake with respect to W3C. I have been very supportive of the process. I would love to see a do not track standard implemented. I think that a lot of folks in the ecosystem have kind of taken, to a certain extent, their own action in the absence of a standard setting organization being able to develop a standard. So you see the browsers being very active in terms of what they're doing with respect to do not track. DAA has its About Ads icon-based program. And so, you know, that's good. They know I'd like to see it improved in many ways, but there are a lot of folks taking action. I think the absence of a standard through WC3 is going to end up, I think, hurting some of the folks who've been most vociferous about the concerns about where W3C is going. That is, I think it's probably going to end up hurting some of the small ad networks, some of the smaller players, because they're going to be faced with browsers taking very pro-consumer, pro-privacy positions and setting up technologies, blocking cookies, other things that are going to make life, I think, more difficult for those smaller players. So I think the technological warfare that people talk about will become greater as a result of the lack of a do not track standard, and I think that's a shame. Now, you asked me, was it a total loss? So again, I don't think it's over. I think there's still going to be some conversation. I hope it will continue on in September. I know they've taken kind of a month break or so. But I think there's also been some important conversations in the context of do not track. So for instance, the conversation about de-identification, re-identification. I don't know how many of you have been following that, but there was kind of a 2-month step away from some of the details of where the group was going with respect to do not track, to look at what do we really mean by personally identifiable information? What does it mean to de-identify the information? What are the kinds of provisions we need to have in place for that? I thought that was a great conversation. It also happened to, I'll note, parallel very well with the points we made in our big privacy report about the 3 things that are needed with respect to any kind of de-identification, which is not just a technological solution, but you need social norms as well. You need contractual provisions. You need agreements to not try to re-identify. And W3C incorporated that in their discussions, and I think that that was great. So even if at the end of the day there's no do not track standard that comes out of the standard setting organization W3C, I think there's been a lot of conversation that people should look very closely at in terms of, for instance, de-identification, re-identification.
Sure, Commissioner, Commissioner Wright, what do you think about this? I mean, if we end up at the end of the day with either no consensus at W3C or competing standards, which I think by some measures folks would consider even worse, what does that mean for consumers? What does that mean for privacy going forward?
It's a great question. This was a new issue for me when I went through the confirmation process and got a question from a senator about, well, where exactly are you on do not track? And I was fairly sure I had no idea what they were talking about.
I gave him that question.
It was well played. So, the commission was sort of out doing work in this area before I came on board. I wasn't there for the privacy report. There are things in the privacy report I like. There are things that I may have, not like so much, but there's a lot of good material in it. With respect to thinking about self-regulation and standard setting, I think about this partially with my economist hat on, and I'm not one of the threshold questions an economist asks himself when they look out into the world for these types of, are we going to have legislation that enforces do not track or something along those lines, is what exactly is the market failure that we're trying to solve? And you juxtapose that question, which I'm not quite sure has been answered convincingly in an evidence-based sort of way. But also, one observes out in the world, I don't think there's a lot of debate over the idea that we're seeing a lot of competition on privacy margins. Now, some of that, appropriate for a conference talking about creative destruction, I mean, some of that competition is going to be between browsers. Some of it may be technological warfare that makes things worse, not better. That's certainly a possibility. And I don't have a particular dog in the fight as to whether W3C coming up with a voluntary standard is something from a commission perspective. I have a strong view that it would be a good or bad thing. I am certainly comfortable with the idea that you have a self-regulatory standard setting body come together with a set of agreements, and that would be a good thing. I have no problem with that. I have less of an enthusiasm, I think, than the commission has as a whole for having the FTC play any particular strong role in encouraging that to come out one way or another or influencing its content. Have no problem at all with people getting together. Now it looks like, and the writing on the wall and the
writing in Politico.
It's everybody's wall. The fat lady warming up her voice and so forth. Look, it's very, very difficult to predict what the counterfactual is, with or without a standard. We are observing, I think, plenty of competition on these margins, and competition can be a tumultuous, destructive, thing until we sort of settle on what the equilibrium is. I'm just not sure that I have any strong views on precisely the content of a standard that would, be better relative to some plausible counterfactual.
Sure. Let me ask one other thing before I turn it over to some audience questions, and that's on data brokers. I mean, Commissioner Brill, we all know where you stand on data brokers and reclaim your name. I'd love to hear you talk, Commissioner Wright, about the role the FTC needs to play here. Obviously, the Commission has been doing this study of data brokers for some time now, but there's been lots of calls for more transparency, for portals, for legislation. What are your views on what needs to happen in this burgeoning industry?
Okay, so no strong views on any particular legislation. I mean, the devil's in the details on different bills. But this is an area where I think I largely agree with where the Commission has stood. I think the idea of, one of the things that makes, and I think I'll go back to what Julie started with, this is a unique and remarkable agency. And one of the things that makes us unique and remarkable is the ability and the appetite to do studies like this and go out and learn about the world, before we act. I think that studies like this are an important idea, if not just for getting some descriptive data about what the heck is going on in the industry and sort of helping to educate us about what's going on. I think that the calls that the Commission and in particular Julie have made with respect to transparency in these areas are fruitful and productive parts of the discussion. So I think this is a place where I largely, again, devil's in the details on particular things, but where I largely line up with the Commission's positions.
Sure, I can keep going for a while, but I want to see if any of you guys have any questions. I don't know if there's a microphone and where it might be. Oh, there we go.
Look at Brooke. I do have one. We have seen in the past so many different stages of alignment on antitrust policies between Europe and the United States. And since we are talking about an area, a technology area, which is still in many ways on a pioneering phase. So how do you see in the moment, how close do you think the antitrust policies are in the moment between Europe and the United States? And do you appreciate everything what is going on in Europe, or do you have different opinions?
Do you want me to do what to start?
I will
Jump
happy
off.
defer if you
So we'll. That's a great question, and our relationships right now with DG Comp, the competition ministry in Europe, have never been closer. We have had a number of cases which have impacted or potentially impacted competition both in the United States and in Europe, and we've worked very closely with our counterparts. Now, we don't always arrive at the same conclusion because the market conditions are different. So if you look at the hard disk drive settlement, that I think we were able to completely align our results because the market conditions were largely the same. If you look at Google, I mean, obviously what's going on in Europe isn't yet done, it hasn't been finalized yet, but let's just know and note that the market conditions in which Google is operating here versus in the United States are very different. The market shares are very different. The penetration is very different. So you're going to have differences just based on market condition factors. In addition, obviously, I mean, for those of you who know a lot about or anything about the European system, on the competition side, it's structured differently. It's not done the same way, and that can too lead to some differences. But as best we can, we work very, very closely. We have a great relationship with Vice President Almunia. So it's relationships that are very close at the top, and it's also at the staff level. And that's not just true with the FTC, it's also true with the Department of Justice. So I think that there's been a great deal of effort to try to coordinate as best we can. We're not going to always get to the same result because of the different system as well as the different market conditions, but we get it that it's very difficult for businesses to sort of be dealing with all these different regimes when it turns out that the market conditions are largely the same. So we are working very closely with them. And frankly, that's also true with the other competition agencies around the globe. We've been working with MOFCOM in China and trying to work with them on issues where we have mutual overlapping concerns, as the Japanese competition authority, the Korean competition authority, a large number of competition authorities. I think at this point now we've actually done some cases where in one case we've had to cooperate with as many as 10 or more different competition authorities. So we strive hard to do that.
So let me piggyback on Julie's remarks, which I agree with all of them, except the Google. I have nothing to say about the Google. That I have no words. But with respect to our relationships with those other agencies, I agree. I mean, there's a lot of work that's done, and I think it's been successful in making those relationships productive and cooperative. With respect to convergence, I think there's a great deal of convergence on when people talk about disagreements with Europe. They're usually talking not about cartels, where the approaches are basically the same, usually not about mergers, where the toolkit's the same and we may disagree because the facts are different, but the toolkits and the process are largely the same. They're usually talking about a handful of monopolization cases from time to time. There are structural differences, private rights of action here, less prevalent there, that lead to different doctrine. So a lot of these things, I think, are those sorts of differences are news because they're infrequent. But also, I think it's also safe to say that outside of the structural differences, there still remain a couple of substantive differences in the law. What exactly counts as harm to competition is a difference in economics, right? I think there's still remains, at least in some lines of cases in the Article 102 setting, I think there still remains some real differences there.
All right, well, should we try for another question, or is it going to rain on you?
It's not raining.
All right.
My question has to do with patent assertion entities. Chairwoman Ramirez said yesterday she's hoping to have something more to say
Thank you so
about
much for asking this.
in the fall, this
Yeah.
fall. The FTC and DOJ held hearings last December, and there's been talk about an investigation, a 6B study for almost a year now, I think. Congress has, well, some of us have been
months.
talking about it.
Several months. Okay.
Certainly since December, okay, at
Okay,
least
okay.
8 or 9 months. The Congress is we heard yesterday at the patent panel actually about Congress is looking at legislation here. The White House has come out with concerns. I'd love to hear from the commissioners about what they think is suitable here for the FTC to play what appears to be a unique role to gather information.
Happy to start.
Go for it. Go for it.
So, with respect to the FTC's role, I have also heard of this study. With respect to the FTC's role here, look, this is a place, I'm an academic economist. I like studies. I think that the FTC is very well suited to do studies on important topics. This is an important topic. So I think this is an area where, with investing time in identifying the right research questions, asking the right people what the questions are, designing a study, as you know, is the devil's in the details on the methodology. What questions are you going to ask and what data are you going to get? But I think this is something we should be trying to do. And for my own sort of personal view, if I get the opportunity to vote on an appropriately tailored 6B study on PAEs, I will vote for it.
So can I just follow up real quick? I have already said I'm very supportive of doing a 6B study. I think the patent assertion entities are a great area for us to get into. But I've also said, and I continue to believe this, that the fact that we might do a study shouldn't stop us, and I don't believe will stop us from taking appropriate enforcement action in an appropriate case. And there's really kind of two types of patent assertion entities, or patent assertion activities, I should say, that could potentially lead to something that the FTC might be interested in engaging in an enforcement action. There's the end user patent assertion entities, that is those who are contacting end users who, they own a fax machine that they bought from someone, or they own some other kind of technological gizmo that has patents associated with it. They're just like a customer. They're essentially a consumer. And a lot of these entities are now being targeted by patents, or some, I guess I shouldn't say a lot, I don't know what the numbers are, but they're receiving letters saying, you're using a machine, you're violating our patent, pay us X amount and we won't sue you. Now, to me, this reminds me a lot of some of the activity that we enforce against on the consumer protection side. Debt collectors aren't allowed to threaten, inappropriately threaten litigation. The toner phoner scams from a long time ago, I'm of a certain vintage, so I remember them, but some of you are obviously much younger than that. But we as consumer protection agencies have protected small businesses, small and medium enterprises when they've been victimized in this way. And to a certain extent, some of this patent assertion activity against end users sounds a lot to me like these consumer protection concerns. Now, there's also concerns on the competition side, our operating entities being targeted inappropriately by patent assertion entities. That may, in the end, present a more complicated question, because competition often is a little bit more complicated in terms of balancing what is actually happening. But it's also something that in an appropriate case, I think that we should take action. I don't know that we need to wait for the study, because I think we have the tools now in an appropriate case to do law enforcement.
I'm sorry, we'd probably have to cut off the question. Okay, we're about to get rained out, but please, so very quickly.
Just
Sorry,
a quick follow-up.
everyone.
So I'm sorry I wasn't at the patent panel yesterday. I had to keep an eye on T-Mobile and Deutsche Telekom and the Spectrum panel. So, but following up on this, I think that there is legislation moving on the fairly fast track in Congress on this. And in fact, I think there was an article in Politico, I forget who said this is one of the 3 things that could potentially move in this Congress. So are you at risk of kind of falling behind the curve a little bit? if you're not moving aggressively on this study, I mean, I could see a timing where Congress acts on this in the fall, and your study comes out and says, oh, you got it all wrong.
You know, I'll just take that, Josh. I think that that's a great point. I mean, I don't know that we're at risk of falling behind, but I do think it would be beneficial to get a study out sooner rather than later. Maybe have it a targeted study rather than a sweeping across the entire spectrum kind of study. But that's something that we'll be talking about very much, I think, over the next couple of weeks in terms of what we ought to do. But you're raising the point that the legislation, you know, if we want to have a role in informing Congress about what we've seen through the study, that maybe should be a factor we take into account, and that's very helpful.
A short comment. I mean, I think that concern. So you said Congress is moving on this, but it depends what the this is. I mean, the this is a portion of the PA problem, much to do with sort of litigation reform aspects of the PA issue. The types of questions that I think are incredibly interesting on the competition side are going to be open questions before Congress acts, after Congress acts, et cetera. Now, you know, they change the rules of the game and it affects the incentives of the players. It makes the study harder to do, right? Because you've got a change in behavior in the middle that you've got to account for. That's tougher, but you've got a bunch of sort of very good professional economists who do that for a living and worry about those types of things. But I think the questions on the PAE side, the role of injunctions in the competitive process, you know, what rate of return these guys are getting, impact on incentives, all of these things are going to be open questions and I think important questions, whatever Congress does.
Well, thank you all for that the great questions and those very thoughtful answers. Really appreciate it. So please join me in thanking the panelists, the conversation. And so that wraps up this year's TPI Aspen. So I'd like to, before we leave, just thank a few people. Thanks Ashley Benjamin, Creel, and Amy Smorodin for all kinds of work behind the scenes, and of course Corey Ryan, who was also Tom's a companion to the hospital yesterday, and of course Jane Creel, who was really responsible for making everything happen. If anything went right, it was because of Jane. If anything went wrong, I'm sure it's because I asked a question and screwed it up. And thank you all for attending. We look forward to seeing you here next year. Register early and often, as they say, for it. And thank you all very much.